I have been researching and studying the European Union for a long time and the law of the European Union. It's a very interesting and unique case of transnational political and economic integration, and it raises all kinds of interesting questions of law, of sovereignty, of effectiveness that I have been pursuing. But one area I've always been particularly interested in is what's called the social dimension of European integration. And that's because the EU, for most people, is understood as, seen as a project of economic integration. It's about market liberalisation and the coming together of different states to enhance their economic fortunes. And the social dimension of European integration historically was not neglected, but very much a side issue. However, in the field of anti-discrimination law, interestingly enough, there has been a strong role for the European Union and for European Union law from the very outset, from the 1950s. And that was encapsulated in a provision in the EU treaties in 1957 on sex equality law. And so I have long been interested in that area of sex equality law. But this current research I'm doing is a new phase of anti-discrimination law in the EU, and that is, it looks at what has happened since the adoption of two major pieces of anti-discrimination law in 2000, extending the EU's anti-discrimination law to a whole range of grounds apart from sex and gender. In other words, to the fields of race, religion, age, disability, and sexual orientation.